Good morning, everyone, and welcome. My name is Tom Pico. I'm the President and CEO for the Penobscot Bay Regional Chamber of Commerce, and we're thrilled to bring you this session this morning in partnership with Eaton Peabody on the topic of legal resources for employers during the COVID-19 pandemic. Before we get to our panelists, just a couple of thank yous. First, I want to acknowledge our premium members who are members that make an additional investment with us. And those include Machias Savings Bank, LCI, Ballou and Associates, and of course, Eaton Peabody, who also is our sponsor today for this session. So thank you all for your support. Eaton Peabody is a terrific supporter of our chamber and chambers around the state, and we really appreciate all that they do to help us. Also, I wanted to let you all know that we are recording this session today, and we'll be making it available later on our YouTube channel. So if you know of folks who wanted to view this and didn't get a chance, we will make sure that that's available to folks later on. So, just on to our presenters. We want to welcome first Sarah Newell. Sarah's a familiar face to us with our legal series here with the Penn Bay Chamber, and she's been a presenter at several other legal series sessions with us. So we thank you for being back. Sarah's a shareholder with Eaton Peabody and represents employers in private, nonprofit, and public sectors, and her practice is focused on labor and employment law. And Rebecca LaPierre, we're thrilled to have you with us as well. Rebecca is an associate in Eaton Peabody's Employment and Labor Practice Group, and like Sarah, is based in their Bangor office. So we welcome you both, and thank you for being here. We're going to spend up to 10:30 with you if we have the questions to sustain that long, and we'll look forward to hearing your guidance to our local business leaders as we navigate the pandemic here. So I want to turn it over to either or both of you for any opening comments you might want to make, and then we can get right into some questions.
All right, well, I'll just jump in quickly because we're going to have Rebecca start with some of the information. But I just wanted to say it's nice to see, quote, see all of you. I took a look at the participant list, and I know some of you, and Tom and I were just chatting before this started that sort of the last time I was there was March 11th, right before kind of this all started, and we were talking about marijuana. So, you know, it's good to see you all again. And we, as you know, I'm a pretty informal presenter. I can see comments at the bottom. So if you have questions as we're going, feel free to, but I know there'll also be plenty of time for questions as we get through. So we're going to present some information, and then we'll open it up for questions and to have a little bit more of a discussion around some of these issues. So I'll let Becca get started on some of the new laws that have come about as a result of this pandemic.
Hi, everyone. I'm Rebecca, for those who don't know me. And in fact, it's probably most of you. Special shout out to my buddy Diane, who I'm sure is watching. But I do not have your questions popping up. So if you do ask questions, sorry if I don't see them, but I'm sure that either Sarah or Tom will let me know.
Yeah, I can relay them to you, so that I'll take care of that. So.
Perfect, thank you. So we're going to get started with a little bit about the FFCRA. I'm sure most of you are familiar with it. If you've been open at all during this pandemic, it will have probably applied to you or affected you. If you aren't open yet, you do need to be aware of this for when you do reopen, because these laws are in place until December. So even though, you know, the major part of this crisis we're hoping is going to be moved past long before then, you know, you might still have residual, you might still have some residual employment issues where this will still come up and come into play. So we want to make sure everyone's fully aware of what their requirements are under the FFCRA. So there's two major parts. One is the paid sick leave, and one is the expanded family medical leave provisions to the FFCRA, which is the Families First Coronavirus Response Act. It was a part of one of the stimulus bills that was passed. And essentially what you need to know is that for all employers who have fewer than 500 employees, which is probably going to be most of our local businesses, you will be required to provide 2 weeks of paid sick leave to all employees, that's full-time and part-time, and possibly even temps, depending on what your situation is with your temps. All employees will be eligible for 2 weeks of sick leave, and that's subject to very specific requirements of when the employee will be eligible for sick leave, and there are some really limited exceptions for healthcare workers as well. So the sick leave requirement has 6 possible scenarios where you may have to allow 2 weeks of paid sick leave, and this is going to be in addition to, on top of any paid sick leave you offer already. What's important to know is that this is separate from your existing paid time off, vacation, sick leave. So you're still going to have to provide any of that you would normally provide, but also for these specific 6 instances related to the coronavirus, you will have to provide 2 weeks of paid sick leave to all employees. And the 6 instances essentially cover when someone is subject to a federal, state, or local quarantine or isolation order related to the coronavirus. They've been advised by a healthcare provider to quarantine, or they are experiencing symptoms of COVID-19 and are seeking medical diagnosis. Now, these first 3 reasons for paid sick leave relate to the employee themselves, and the things that you should be aware of are that for reason number 1, where they are subject to a federal, state, or local quarantine or isolation order, they must actually be subject to a government order. It's not necessarily just anyone telling them that they should quarantine or isolate. It would be, for instance, if someone leaves the state and then comes back to Maine and they're subject to the governor's mandated 2-week quarantine for entering the state from another state, then they would qualify for that reason number 1, which is the federal, state, or local quarantine order. If you as an employer say, I don't want anyone coming into my office if they've been out of the state or out of the country, after the governor's order has been exhausted and is no longer in effect, then they would not be eligible for the 2 weeks of paid sick leave under the FFCRA, because that's the employer telling them to stay home, not a government order. So as long as there's a government order in effect that says that they have to quarantine, then they would be eligible. If there is no official order from a government entity, then there is no requirement. In terms of a healthcare provider, if the healthcare provider has advised them to self-quarantine because they are high risk or because they've been near somebody who was infected and their healthcare provider thinks they should self-quarantine, again, it has to be a healthcare provider telling them to self-quarantine or isolate. And for the individual who's experiencing symptoms and seeking medical diagnosis, again, the key thing here is that they are seeking medical diagnosis. Medical diagnosis. If someone says, I'm not feeling well, I don't want to come in today, but they don't bother to seek out a doctor to try and get tested, then they would not qualify for this particular paid sick leave. There's also 3 categories of reasons for paid sick leave that relate a little bit more to if someone else has something going on in their house or their family. And those 3 reasons are actually going to only be paid out at 2/3 the rate of pay. It's not the full rate of pay. And that's for if someone is caring for an individual who is subject to an order as described previously. So someone who is caring for a family member or a spouse or a domestic partner who is being told to quarantine under a government order. But So that's going to be really limited when that is applied. And then reason number 5 is where we get a lot of confusion because it overlaps with the Expanded Family Medical Leave Act provisions. And this is a reason for paid sick leave, 2 weeks of paid sick leave, due to caring for a child whose school or place of care is closed for reasons related to COVID-19. And like I said, it gets a little confusing because that's the same type of leave that would be covered in the Expanded Family Medical Leave that I'm going to talk about next. They can use this 2 weeks of paid sick leave for that purpose. Number 6 is for any kind of situation where an employee is experiencing a substantially similar condition specified by the Secretary of Health and Human Services. I haven't seen this applied yet. I'm guessing it's sort of a catch-all for just in case some other scenario happens where the government decides that we need to use this sick leave. So like I said, for the first 3 reasons, you're going to be paying the employee at the full rate of pay, and for the following 3 reasons, relating to caring for someone else or for a substantially similar condition, those are going to be at 2/3 the rate of pay. We do have a really helpful chart if you're unsure about which type of leave gets which pay. Let us know. We can mail you that or email you that chart that shows you the breakdown as well as the caps of how much you are required to pay out, because each of these paid leave provisions is subject to a limited cap that you are required to actually pay out. And if you decide to pay beyond that cap, you can. However, the only amounts that will be eligible for a tax credit that I'm going to talk about later as well are the amounts within the capped limit. So the next thing that we're going to talk about is the Expanded Family Medical Leave, and that is where we get a little confused for a lot of employers because it's frankly a confusing law. So we've got a law that is requiring a new type of family medical leave, a new reason for family medical leave, and this new reason requires part of the family medical leave to be paid. So now, if someone has to stay home and is unable to work or telework because they are caring for one of their own children who is out of school or their place of care, like their daycare or their babysitter or their nanny or whoever is unavailable due to the coronavirus, then that employee is eligible for 12 weeks of family medical leave. It is only for childcare related needs related to the coronavirus. If the employee is able to telework, if they can work from home, then they will not be eligible for the family medical leave under this provision. If they are unable to work or unable to telework, then they get 2 weeks unpaid of family medical leave time and 10 weeks paid at 2/3 their rate of pay, subject to a cap. Now, the reason this gets confusing is because the employee may use the 2 weeks of paid sick leave under reason number 5, which is to care for a son or daughter whose place of daycare or school is closed. Those 2 weeks of paid sick leave can be substituted into the first 2 weeks of family medical leave so that 2 weeks is also paid at 2/3 the rate of pay. Also, if an employee chooses to, but they cannot be made to, the employee can elect to use their own accrued paid time off to cover any of this leave. Now, again, this gets a little confusing because if they choose to use their paid time off to cover the unpaid portion, or because they want to receive their full rate of pay rather than 2/3 the rate of pay, the tax credit is still going to be limited to the amounts capped within the law. However, the employee could say, I would really rather use my vacation time and get my full rate of pay for this period, in which case you would have to have a conversation with the employee about what their options are there. So, happy to take any questions about that. Just trying to give the basics of it. But those are essentially your 2 paid leave requirements under the FFCRA. As I mentioned, there is a tax credit. It's a payroll tax credit. It is meant to fully reimburse you for the amounts that are paid out for these paid sick leave provisions. And the things to be aware of are that if you're taking one of the SBA PPP loans, you cannot double up on both loan forgiveness and a payroll tax credit. It's one or the other. And if, like I said, the employee uses their own paid time off, or you choose to pay them at their full rate of pay when they were only eligible for 2/3 the rate of pay, you're going to be subject to those caps on the amount that you can get a payroll tax credit for. So those are the basics of the FFCRA. Do we have any questions about FFCRA before we move on?
I see one in the chat and I can relay it to you. It just says, so if an employee leaves the state right now, the employer is required to pay them up to 2 weeks of sick leave due to the government order for a 2-week quarantine being in effect. Example, an employee goes to Massachusetts for whatever reason and or decides to take a week vacation in Florida.
Becca's really used to answering this question because we get it all the time.
Yes, it is a pretty common question. We've been advising employers to create policies that are in effect as long as the governor's order is in effect, stating that either that vacation will not be approved for anything that is not in compliance with the governor's orders, or alternatively working with us to come up with some sort of solution to help try and prevent employees from just willy-nilly leaving the state and then coming back and requesting 2 weeks of paid sick leave. The things to remember are that they only get the paid sick leave once. So if they decide, I had this great example from one of our clients asking, what if they decide to just shoot down to New Hampshire to the liquor store every week, and then they come back and say, I want another 2 weeks of paid sick leave? They can't do that. It's 2 weeks total that they are eligible for. If they decide to leave the state and come back and are subject to quarantine orders every time, they're going to end up probably sitting at home on unpaid leave, unless you have telework for them to do. So yes, if an employee leaves the state, if they go on vacation, if they just decide to go to the liquor store in New Hampshire, then that will currently, while the governor's order is in place, that will require the employee to take 2 weeks of quarantine time once they return to the state, and they would be eligible for this 2 weeks of paid sick leave for that purpose. That said, it's certainly not an advisable move for any employee, especially if they think they might actually need the paid sick leave for a legitimate purpose down the road sometime. So we're hoping that employees are going to do that, and we will work with you to create a policy if you need to, that will hopefully prevent employees from making those decisions to leave the state, where you would then be required to give them the 2 weeks paid sick leave when they return.
And, I'll just jump in. When we say create a policy, I know some of you here are very small employers. If you don't have written policies, sometimes it can be as easy as a communication to employees that just says, effective immediately, we're not approving vacations. We're not approving vacation time for time spent out of state due to the governor's orders. It can be something very simple like that. And I think the key is, if you've got employees that you think are abusing this situation, you want to deal with it on the front end, because you do have control over your vacation policies, and you have control over what you approve for vacation and how you approve it. What you don't have control over is dealing with the employee after they've taken this leave that's eligible for the sick leave, because I think you are going to have to kind of swallow it and pay the leave, because there are also non-discrimination provisions under the law. So you can't, you wouldn't be able to terminate an employee for not, for going out of state and then being eligible for this leave. However, if you had employees that you were saying, your vacation is not approved, and then they take off anyway, that's an insubordination issue that you could deal with. So you just have to kind of handle it correctly. And Becca's right. At the worst, the maximum's 2 weeks for that employee, so, of the paid leave.
Super. Thank you both. So I have a few questions that have been submitted in advance, and I see people posting in the chat as well. So I'm going to try to do my best to work back and forth on those. If any of you are so inclined to raise your hand and want to chime in on your own, I'll try to mix those in as well, and just ask you to keep your question succinct so that we can get to as many as possible. But let me go to one of the pre-submitted questions, because this is likely the question that I hear most frequently. How do you handle the refusal of an employee to return to the office setting as they have been working from home during this time? Been set up remotely simply to reduce the number of staff in the building, and they did not have any daycare or underlying health concerns or those of family they are caring for.
Yeah, I'll take that one. And so this is an issue that's coming up a lot, and in part because of the additional $600 that's been provided at the federal level for unemployment. We have some employees who are doing as well, or in some cases even better, under unemployment for wages. And so sometimes it's been challenging getting folks back. First of all, I think it's important to have a clear, be clear with the employee that their job is available and you're expecting them to come back. From your side, you can indicate to employees that their job won't be protected if they aren't coming back, that you can't guarantee that you'll have their job for them. The other piece is that I know Rebecca was on a webinar with the Department of Labor, and one thing that they said was that employers should alert the Department of Labor when they call employees back. The question I have about that is how, because it's nearly impossible to get in touch with the Department of Labor at this time. If you're submitting your unemployment claims online, there is a part of that process where you can amend a claim. You may do it that way. You may do it by trying to get in touch with the Department of Labor and just indicating that as of this date, the employee was called back. Unless there's some other reason why the employee would still be eligible for unemployment, even despite the callback, then it's my understanding that the Department of Labor will that their unemployment claims going forward will be denied because they have work available. That might take some time to catch up, is part of the problem. So, and that happens sometimes. The employee may very well receive unemployment for a few more weeks before that catches up. Unfortunately for the employee, they will likely be asked then to pay back those portions of unemployment, and they will not have had the benefit of their salary. So, you can indicate to them that the Department of Labor has indicated we have to report callback dates, and see if that kind of nudges the employee to come back to us. The only caveat I would give is we have to be careful when we tell them what unemployment will do, because unemployment is unpredictable sometimes, and it really is not. We have no control over what unemployment does or doesn't do. So that's the caveat, but that's what I would do.
Great. Thank you. So next question from the chat. If an employee was furloughed due to lack of work and had kids who needed care, is FMLA or unemployment the best route?
I can grab that one too. So if you furloughed an employee, they technically, they're out of work. And so they're not going to be eligible for the FMLA leave because they've already been furloughed or laid off. So, and then they can apply for unemployment. So they're not going to be entitled to that leave unless they're called back to work, at which point that may occur. So that would be my answer there.
Great. Next, what if you have an employee who is older with health issues who wants to come back? Does this open the organization up to age discrimination issue? The older employee is able to work remotely, but misses getting out of the house and wants to come to work.
Yeah, so for that one, I think you have to be careful just to treat all your employees equally. And so if you've made if you are allowing people to opt in to coming back to work, then and that employee asks to opt in, I think you would allow them to come back to work because they, there's no reason that they can't. If you aren't having people come back to work, then I wouldn't have that employee come back to work. Whether you're opened up for any additional liability, I think you have more liability by saying no. You would saying no. I know that you're, in a protected class. You're 65 and you have heart disease. We don't want you coming back. That's going to cause you some problems. So I think you just have to treat everybody evenly.
Thank you.
Yeah, and I will say we do see that question a lot. I think there's a lot of people who are really itching to get out of their houses and not always, in their own best interest, but unfortunately we don't get to decide for them in the end if we are open and your concern about potential age discrimination is legitimate, or with any class. If you have individuals that have history of illness or health issues and they aren't raising that as a concern and they're not requesting that they be able to continue to stay home, you do have potential disability discrimination or age discrimination claims if you don't allow them when they're asking to come back and you're letting other employees come back. Unless, of course, if you do have concerns, you can always do a staged return and set up groups of employees to come back slowly. But you want to make sure that when you're doing that, the way you're doing it is an equal opportunity for all employees and not necessarily a clear staged increase of employees where you have the youngest and healthiest coming back and then slowly, gradually getting to everyone else. Then you could potentially have problems as well. So if you are having staged shifts or staged returns to work, you want to be careful that you are how you're choosing those employees to come back and when they're coming back so that it doesn't appear to be discriminatory.
Thank you. So I've had, back to pre-submitted questions, I had a few here. I'll try to work these in from a local childcare center, but I think they apply to lots of employers. If I have a staff member who is pregnant and doesn't feel comfortable coming back to work and her job cannot be done from home, what options does she have?
Yeah, so these questions do come up a lot for employers. And as we start calling people back to work, they're going to come up more and more. So you can take a couple of different approaches with this. If it's an employee who has a medical reason that they can't come back and they have a doctor weighing in and saying you shouldn't be working, then we kind of have to think about the ADA and the Maine Human Rights Act and whether we have to accommodate them being out for an additional unpaid period of leave, which we probably do, depending on what the time is. And as you know from other talks we've had, that's a pretty individualized assessment that you have to do. So if that employee's doctor is saying, yeah, you shouldn't be coming back, then that's one thing. If the employee is just saying, I don't want to come back, and they don't have a medical reason, including a medical reason related to the pregnancy, I think you do have some flexibility on whether you agree to leave the employee out or whether you say, I'm sorry, we need you back at work. And I think you can take that approach either way. People, I know, this is a difficult time. We do have to be gentle with our employees, and we have to understand that, there's just such, as you're all seeing now, there's such a wide variety of how people are dealing with this. I mean, you have some people who are just scared to go out on their porch, and then you have others who are just angry that there's any kind of restrictions at all, or that they have to wear a mask, or, there's a wide range. So we have to be thoughtful of that. But you do have some control to say, yeah, no, we're calling everybody back to work and we need everybody back, as long as there's not a health reason. Becca, you might have another I don't know if you have other comments on that.
Yeah, so one of the things you can do if you're having trouble either just getting you know, sort of negative feedback from employees, or you know, maybe you haven't even tried to call them back and they're already telling you that they're scared to come back. Like Sarah said, there's a lot of anger and there's a lot of fear out there. Some people are angry and afraid about the virus. Some people are angry and afraid about, you know, the restrictions. And we have to be sensitive to that. I think it's a little bit easier to deal with a lot of that fear if you just take a little time to reassure your employees and prepare ways to inform your employees and make sure you're communicating with your employees of what you're doing to protect them. I think that a lot of this fear comes from you know, the unknown and thinking, well, I've been told it's not safe to go out, so why are you telling me I can come back to work? So I think what we need to do for our employees is make sure that we're communicating how we are keeping our environments, our work environments safe and clean and sanitized, what steps we're taking to prevent employees from interacting with each other or with the public too much. And so the OSHA has actually created some guidance for preparing workplaces to return during COVID-19 pandemic. And a lot of that includes sort of what you should be doing and how you should be dealing with safety issues, excuse me. But it also includes a breakdown of sort of the highest risk environments to the lowest risk environments. Office jobs, places where people aren't necessarily going to be interacting too much, are considered low risk versus, for instance, a healthcare provider who is interacting directly with patients who have tested positive is obviously going to be the highest risk. And then there's everything in between. And I think being able to figure out which level you classify your business as, and then making sure you're taking the steps to prevent infection or spread of disease, and then reminding your employees that you want them to be safe, you care about their safety and their health, and you're doing everything possible to make sure that when they come back to work that they are going to be in a safe environment, and these are the things that you're doing. That should reassure those employees and make them a little bit more comfortable to come back to work and to feel secure that their employer isn't just forcing them to come back when something's not actually safe. You know, because a lot of this fear isn't always necessarily based in rational thought. It's not necessarily based on, you know, reasoning. They're just thinking, I've been told I shouldn't go out and now you're telling me I should, and they don't understand why or what's going to make them safer if they come to work now. I can give you an example. Just for instance, at the firm, we've been, you know, getting updates regularly about the additions to our office that are going to be in place when we return, including things like plexiglass to keep people from spreading germs with each other when they're in common areas. So I think if you are communicating that to your employees and making sure that they know that you are ensuring that your environment is going to be safe for them, that you've taken the precautions, and that you're going to do everything you can to make sure that they're safe when they come back to work, that's going to help you boost that morale and get people to want to come back, the ones who maybe are a little more afraid of returning. And I think even for the folks who maybe are less happy about the restrictions, they might not like being told that they have to wear a mask at work. If they understand why they're being asked, that they're being asked to wear a mask to protect their coworkers, they might be more understanding of that as opposed to just being told they have to do something for the sake of doing it.
Great. Thank you. So, I'm going to hit one more question from the child care that submitted questions in advance, and then I'll jump back to the chat for a minute. But under the FFCRA, reason 5, if a staff member cannot work because school is closed, can they only take leave until school is officially out for the summer? If a staff member typically has a family member watch their child for the summer, but the family member is unable to do so, do they qualify for leave under that, even if school is not in session for the summer?
So I'd say the answer to that is maybe. The regulations that are proposed by the Department of Labor do talk about what we can ask an employee for in order to qualify them for that leave. So what we can ask the employee to do is to certify that there's not another appropriate caregiver available for the child. I've gotten this question a lot too. I do think, and Becca has really dove into these regulations in a way that probably is deeper than I have. But I do think that we can, at the end of the school year, go back to, if employees haven't used their full entitlement, go back to employees and see what their plans are for the summer, and whether their planned childcare for the summer months is available at this point. If it is not, and they can certify that there is not another person available to care for them, they may be entitled to additional leave. I mean, remember, the period of leave that's available is only 12 weeks. And so by the time we get to June, most people will be fairly close to that if they've taken the entire time. But if you've furloughed and you've just gotten people back, and they may not be. But Becca, you might want to jump in.
Yeah, I think that's pretty much everything. It's, it's not limited to schools being closed or to daycares being closed. It's generally if the child care provider is not available. So that could be, their in-laws or a family member or a babysitter. It could be anybody. If that person or that daycare isn't available, then they will still be eligible. But like Sarah said, it's limited to 12 weeks. So if they're already using their time, they may run out. And then it's up to you if you want to give them additional unpaid leave, or if you want to say, that's it, that's all we can do if you got to come back to work. There's also options to use this leave intermittently. You do have to come to an agreement with the employee and the employer together. But so for instance, if an employee says, my child care is unavailable this summer as well, even once we're into summer break, I know normally I would have been able to work over the summer, but right now I can only get child care in the afternoons, or I can only get it in the mornings, and I don't have it for the full day anymore. Maybe their day camp is closed. So in that circumstance, what you might want to do is have a talk with them about whether or not you could alter their schedule so that they can work different hours, or also offer intermittent leave where they maybe take half a day of FMLA and work half a day when they do have childcare. So there are some options to work around that, but yes, you will be probably be required to provide FMLA leave under this law if their normal childcare system, whatever it is unavailable, even over the summer, even if they normally would have had someone, because it's for all childcare related issues. So it doesn't have to be a school closure. And like Sarah said, there are certain things you can ask for. You are limited in what you can ask for documentation from that employee. But if it's something like a school closure or a day camp or a child care center where it's an entity of some sort, they should be able to provide you with some notification of that closure, whether it's an email from the business or a newspaper notice or a website notice that says we're closed for the season. You can ask for that to be provided. If it's something like a family member who usually watches their kids who either had to go back to work themselves or is unavailable because they can't be out due to a high risk, something like that, then it's really just going to be a matter of taking the word of the employee at that point. But again, they're limited to the 12 weeks. So it can only go on for so long.
Thank you. Back to the chat, and a question about if we get the Paycheck Protection Program loan and an employee wants to request paid sick leave in the 12 weeks, do we get that back in our tax break or not, because we already have the PPP loan?
So if you are including those payroll costs in the amount that you're asking to have forgiven, so if that paid sick leave that you're paying out is part of what you're requesting for forgiveness from the SBA PPP loan, then no, you would not get the payroll tax credit for it. You can't double up. However, if if you're not requesting that portion of payroll to be forgiven, you could use it for the tax credit.
Super. Okay. So, and the next question is pretty similar, but just make sure we cover it all. If a company took advantage of PPP, they are still subject to pay employees under the FFCRA. That's right.
Yes, that is correct.
Yep.
Even if you got PPP monies, congratulations. But yes, you are still required to pay FFCRA related leave unless you have over 500 employees, in which case you are not subject to the law, or in limited exceptions, if you have healthcare employees, we would advise that you talk with us or with your attorney about that, because it's a bit of a gray area of where the exception applies. And then there's also a really limited exception to the FMLA for employers with fewer than 50 employees if they would essentially go out of business due to allowing this paid leave. So they're very limited exceptions. If you think you might qualify for one of the exceptions, we would recommend that you talk to your attorney, give us a call, email us, and we'll be happy to kind of analyze your specific situation for that.
We had a couple of questions from a seasonal rental owner. One being, regarding protections against a renter who might claim that they contracted coronavirus from renting their property.
Yeah, that's an interesting question. Haven't had that one before. I think the key is in any of those sorts of cases. So if you're on the employee side and an employee contract is claiming that they've contracted coronavirus through you, you're dealing with a totally different system of law. You're probably dealing with workers' comp, and your insurance company is going to work through that, and it's all going to sort of be taken care of under that area. This person's asking about a customer coming and claiming that that they've been injured by contracting the coronavirus at your location. So that is really a question of negligence and whether we're negligent. And I'm not a litigator. I don't. So this isn't my area. So this is a very cursory answer. But when you're talking about those sorts of answers, the key is what is your duty to those people who come and stay in your facility. And so I think the best way to avoid those sorts of claims is to ensure that you are up to speed on, so as we know, the governor, as she's been rolling out sort of this return to work, has checklists for different businesses for what they're supposed to do. I think you want to be aware of all those things. I think you want to follow those requirements, those checklists. And if you're doing all of that, if you are following the advice that is coming from the governor's office in terms of, or I guess it's not advice, they're orders, that's coming from the governor's office as to what you need to do to make sure that your business is ready to be up and running safely, I think that's going to go a long way to showing that you've done your duty to keep those people who come safe. You want to make sure that your insurance is all up to date, that you have insurance coverage for, your general liability insurance. Some of those sorts of claims may be covered under insurance. So I would say those are the things that I would do to make sure that you don't have issues there.
Yeah, and we have had some businesses and employers asking us to create waivers for them that they can either post or have consumers sign off on. We don't always recommend that. Sometimes a waiver could actually, potentially get you into more trouble if it's not appropriate in the situation. But at the same time, if it is appropriate and if it's enforceable, it can help you. And so in the instance of a renter, a waiver might be a good idea because that's a little different than an employee-employer relationship. So that's something that you might want to talk to your attorney about drafting as well. And then also the Osha requirements for businesses under COVID-19 reopening are requiring certain reporting to exist for if someone is claiming to have been sick or to have gotten sick at work or at your place of business. So that's something you're going to want to pay attention to as well, is whether or not, if someone is making that claim, like Sarah said, it's something you're going to want to talk with workers' comp and your insurance provider, but you also will want to make sure that you're following OSHA guidelines for reporting and recording. Sometimes you have to report, sometimes you just have to keep a record. So it really will depend on the situation.
Great, thanks. So another question along the vacation rental line. Would you advise that setting up a cottage rental as an LLC would be something that you'd recommend? Would that give any added protection to a cottage rental owner?
So sometimes, I mean, again, this is sort of outside the scope of our practice area, but there are sometimes employers do, or not employers, but business owners do set up either an LLC for their actual business, or they have a business and they have a separate LLC that's like a property holding company, and that is used to limit the liability that you might have for a personal injury on the property. There are some things that can impact that, whether that liability insulation is actually there. And you know, that includes how closely run those companies are together and how the owner deals with getting profits and things out of the company. It's a little outside the scope of what we talk about, but I do think that's a possibility for liability protection that's worth exploring with your own counsel.
Yeah, and like Sarah said, this is sort of outside of our scope, but generally speaking, an LLC or corporation is going to be more protective to the individual because there is some protection from personal liability. But there are also ways to get through that and to still come after the individual. So you want to make sure that if you are setting up your business as an LLC or as a corporation to try and protect yourself, make sure you do it properly. Make sure you have a good lawyer drafting up all the paperwork for you, because there can be protections, but it has to be done right.
Yeah, and the other thing I think that's key about doing it right is making sure that you're working with an accountant as well, because some of the things that end up creating the liability still for the individual, even if they're under the LLC, is how you're dealing with the funds in the business. And an accountant is able to pick up those issues right away and tell you, no, you can't do it that way. That's going to create issues for you. So,
yeah, and lawyers can barely count, so definitely get an accountant for that.
Great. Thank you. Next question. If an employee who has returned to work tests positive for COVID-19, what is the most appropriate response from the employer? For example, what should the planned response be, and is the company required to protect the identity of the sick person?
So I'm going to have Becca talk about whether that's addressed in the OSHA, the new OSHA provisions, but in general, yes, we do have to protect the identity of the person. And by saying protect the identity of the person, I mean the employer cannot share that the identity of the individual with clients or coworkers or anybody else. But the employer can and should inform individuals who had close contact that someone has tested positive. Now, I know that in some of your small business settings, it's going to be obvious who tested positive, but as long as we're not sharing that per individual's name and not sharing information about their health, then, you know, we are able to use that information.
Yeah, and I'm sorry, could you repeat the beginning of the question for me? I think I missed it.
Sure. Let me go back to that. So if an employee who has returned to work tests positive for COVID-19, what is, I think the point is planning ahead for an appropriate response in case that happens. What should employers be doing in advance to prepare for that eventuality, and to have a response ready? You know, how should they plan to respond if someone is diagnosed or confirmed to have COVID-19?
Okay, great. Yeah, so this is covered in the OSHA guidance. They do have guidance on how to create a plan of action for if someone is exposed or if an employee tests positive. It's going to be different for different businesses. Essentially, you will have either recording or reporting requirements, but you also will want to make sure that you have a very set plan of action in terms of how you're going to clean that space, how you're going to notify employees without sharing personal information, because as we mentioned, you can't share that employee's name or information, although you do have an obligation to tell employees that they may have been exposed. So we want to make sure that we are implementing or making a solid plan. And if you need help making that plan, if you're not sure what to do, that's something that we can work with you on, because you want to make sure that you've covered all of the required elements under OSHA and state law for protecting employees, and also make sure that you have actually addressed any potential sanitation issues or exposure issues with your other employees, and like Sarah said, keeping the privacy in place as much as you can is important. Again, like we said, with these smaller businesses, if you only have a few employees and one of them goes out sick for a long time, everyone's going to know who it was. But as long as you aren't actively telling them or sharing the name of the person, you should be protected on your end. But again, the OSHA requirements are going to depend on what level of risk your environment is. So if you're a higher risk environment, you're going to need to do full-on sanitation, probably, of the entire space where that person may have worked or entered. If you're a lower risk environment, you might only have to clean common areas or their personal workstation. And I think that one of the big things is recognizing what common areas you do have ahead of time, so that you know that those areas are being maintained before you have any potential exposure, as well as if there is an exposure, you want all those spaces where people may be interacting or lots of people are coming through, your lobbies, meeting spaces. Those spaces really need to be areas that you pay high attention to, and really discourage employees from spending too much time interacting. Really enforce your social distancing in your business place. Make sure that individuals know that there will be enforcement mechanisms in place if people are ignoring social distancing, if they're not wearing their mask when they're supposed to be. And that's something I think Sarah's going to talk a little bit about in terms of when you can require certain things of employees before coming into work or while they're at work. But we do have a new executive order from the governor that does require face masks in certain settings. So there are certain times where you can require that for employees, in that, and hopefully prevent potentially getting any exposure for your employees. But if there is an instance where you have it, you want to have that plan in place ahead of time. And you want to make sure that it is appropriate for your type of business, and covering the specific areas that will affect your employees and your type of business. So it depends on if you're public facing, if you're a private office space where the public doesn't come into, if you have an office space where people are generally kind of in their own cubicle or in their own office, you're probably going to have less steps to take on your exposure response plan versus if you're a healthcare provider where people are interacting with their patients, or employees have to physically interact in order to get things done. If you're a restaurant where you have the public coming in to get food or potentially could be exposed to your employees as well, then those are all going to be factors that you need to take into account when you are creating your response plan.
Great, thank you. Next question in the chat. Just clarifying that a new hire is available for the entire FFCRA from the first day of employment. Just confirming that that's the case, and even if they had collected some or all of this from a previous employer, and how would a new employer even know that they had done that?
So no, a new employee is not necessarily eligible. Um, so let me just pull up the exact amounts of time that they have to work for.
Yeah, while Becca's doing that, I'll just point out that this raises an issue that I meant to sort of chime in on. You may be a small employer who's not used to being covered by the FMLA, and the FMLA itself has certain coverage requirements, like for the federal level, that you have 50 or more employees. That isn't the case under this law. If you have 500 or less employees, you're covered. And there is not a requirement that the employee work for you for a year like there is under the FMLA, which is what I think this person is kind of raising here. But there is a requirement that the employee has worked for you for a certain amount of time, and Becca can get into that because I know that's what she's looking at.
Yeah, and it's funny. I covered this so many times, and now I can't remember what the amount of time is.
I think it's 30 days.
I think you're right.
Yeah.
If you want to go on to the next question, I'll look that up and get you the answer, because I think
Sure.
it's different for the paid sick leave and for the FMLA leave.
Yeah.
So I just want to make sure I have it exactly right.
Great. Okay. So yeah, we'll move on and come back to that answer. But the next question is, can we require that visitors to our business provide email or other contact info in the event that someone later tests positive?
So you certainly can. I mean, the fact is people can, this is kind of, you're seeing this like all over Facebook. You've got half the people who are really worried and what, making sure that people, that businesses are protecting people. And then you have a large group of people who are also upset because they think it's sort of a violation of their rights to either provide information or to, have to wear a mask or to do that. But yeah, I mean, it's your business and you can require your customers to provide information to you if you think that would be helpful. I know under the governor's orders, there are some, and her checklists for returning, there are some businesses where that's where the governor's requiring that in order to be open. So I think, for example, restaurants, I think the governor's checklist on restaurants requires the collection of contact information so that if there is a spread that those folks can be gotten in touch with. So yes, you can. That's also sort of a PR kind of question as to how you're going to handle your customers and deal with them, those who have both sort of opinions on the issue. But people have a choice to frequent your business or not. So it's not really a, you're infringing on my rights sort of question, because you're not the government asking them for this. You're asking them for it so that they can use your business.
So just to jump in quickly, yes, it's 30 days of employment for an employee to be eligible for FMLA. So for the expanded FMLA leave, rather, they must be employed with you for 30 days before they can receive that. The paid sick leave is for all employees, like we said. So the paid sick leave will be for someone who is a brand new employee. But the FMLA leave is only for employees who have been with you for 30 days. And the question about if they've used their leave with a former employer, it's employer to employer. So it's the eligibility. It's not, that they get 2 weeks of paid sick leave ever in their life. They get 2 weeks of paid sick leave from each employer, or they get the FMLA leave from each employer. So if they used FMLA with another employer, then they came to you and they immediately said, I need FMLA. Sorry, that's not a great hire, but at the same time, they will have their FMLA leave available to them because you're a different employer. But only after 30 days, yes. Also, regarding what Sarah was just talking about with the requirements under the governor's order, the face masks are part of the governor's updated order. cloth face coverings are required by the governor in certain circumstances and are allowable at the employer's discretion in other circumstances. So what the order says is that employers in settings that are not typically accessible to the public may determine the persons who should wear a cloth face covering at their workplace and shall permit any employee who wants to wear a covering to do so. So if an employee is requesting to wear a face covering, you have to let them, even if it's not required. But if an employee, or if you want your employees to wear face coverings, even though they're not one of the required entities, the governor's order is giving you permission to require that. And, we may have some questions about whether or not that's permissible, but as of right now, that's what the governor's order said. And like Sarah said, depending on the type of business you're in, it may be actually required under the government order. Generally speaking, they're requiring the face masks in what we call public settings. They're defining the public settings as indoor spaces where the public has access. So grocery stores, retail stores, pharmacies, anywhere that the public is actually coming inside of your business. And then also for outdoor spaces such as playgrounds, a busy parking lot, or other areas such as a line for a takeout service. So if you have anywhere where you're having a line of individuals, even though they're outside and they're social distancing, that is part of what is being considered a public space where they're required. And then also for any sort of public transportation, which if you are a transportation business, that's something that you will really want to pay attention to, because this is including ride sharing, it's including ferries, it's including buses, taxi services, anything like that. They will be required to wear a face mask.
Thank you. Just back to questions from a local childcare provider, and these are kind of tied together, and I do think apply to other employment situations too. If an immediate family member of a child in childcare tests positive for COVID-19, should we exclude the child from being able to come to childcare, even though the child themselves wasn't diagnosed, but somebody in their household? And same thing relating to an employee of the childcare center. If a staff member's relative in their household tests positive, should you prevent that employee from coming to work?
So Becca, I'm not sure if the governor's orders cover that, but and then this is a good time to say that these sorts of questions, the answers to them are changing as we go along. So you may hear something here that may change depending on a new order by the governor or a new guidance under these laws or something like that. So just be mindful of that. But in general, I've had this question from employers. So what happens, if a family member of the employee tests positive and they're not trying to take time to stay home under the sick leave law, but they want to come in. And I think that is, an employer may say, no, we're not going to have you come in. That leave, unless a doctor or the government has said that they have to be out, is probably not going to be covered under the Paid Sick Leave Act. So that's something to consider. Whether if a child themselves tests positive, I would imagine that you would not have the child back to the care facility, because I believe that they will be ordered to quarantine or to isolate actually at that point under the law. If somebody in the child's household has tested positive, you probably have more flexibility in terms of what you decide to do. But Becca, I'll have you jump in terms of what the OSHA requirements might say about that, and whether there's specifics in the governor's orders on opening those sorts of businesses at this point.
Yeah, so I'm not sure about in terms of if someone has someone in their house who's been exposed. I would say if that person is then self-isolating in a room where they're not being exposed to other people in their family, then you might not have as much of a problem. But again, it's going to depend on your business and how, like, you know, so for instance, a child care center, if you know that a child has been exposed, you know, and we know that a lot of kids don't show symptoms and could still be carriers, it's probably a safe practice to say anyone who's been exposed should not be coming in, because you're in a environment where kids are interacting. I should also note that regarding the face masks, there are exceptions to the rule, and they include, for instance, certain children and childcare environments. So, you know, if you're in a situation where you know, you're not going to make a bunch of 3-year-old kids try and wear face masks while they run around. There's a higher chance that an exposed child could spread the disease there. So you're going to want to be more careful. Versus if someone's been exposed, but they work in their office and they never really come out or see anyone, you have less of a concern. I don't think that there's any specific law that I'm aware of yet. And like Sarah said, these things change a lot, so it could come out with something. As of right now, I don't believe there's anything that requires individuals who have exposure to actually quarantine. I'm going to double check on that, but I'm pretty sure there's nothing that legally requires them to if they've just been exposed and have not had symptoms or had a actual diagnosis. In terms of the paid leave, if they think they've been exposed and they're trying to get testing, and they maybe have some symptoms, then they are going to be eligible for paid leave. Or if they've been exposed and their healthcare provider says, you've been exposed and I think you need to stay home, if their healthcare provider is saying that, then they would be eligible for paid leave. I think that with this stuff, with the exposure, it's really important to listen to what the healthcare providers are saying. They're the experts in terms of whether or not someone is highly contagious or likely to have spread the virus. You know, unfortunately, a lot of the time someone gets diagnosed or we find out that they've been exposed a long time after the fact. They might have already been past their 14-day quarantine period when they find out that they had been exposed, and have already been out and about. So, you know, we have to deal with those instances as they come. The other thing to note in terms of if there's been an exposure is, you know, how close the individual is to the person that they were exposed to. If it's their spouse that they sleep in the same bed with every night versus if it's their grandma that they saw once from a distance, probably less of a risk. I do think it would be important to have policies for your business, for yourself regarding, and you know, again, this doesn't necessarily have to be written policies, but maybe just a notification to your employees that you don't want them to come in if they've been exposed, and making sure that that's applied equally and evenly with all employees. We've got to be, again, really careful about potential disability discrimination or age discrimination if we're saying, you know, there's been an exposure and now we don't want anyone over the age of 40 coming in. That's the reason I say age of 40 is not because that is the high risk category, I would point out, but because age of 40 is where the ADEA, which is the age discrimination law, kicks in. So anyone who's over the age of 40 is protected from age discrimination. I also want to point out really quickly, this is a little bit unrelated, but I didn't mention it before with the face masks, is that there are also limitations or exceptions for individuals who have healthcare reasons for not wearing a face mask. So you do need to be aware of that in terms of potential ADA compliance. If someone is saying to you, I can't wear a face mask due to health concerns, because of maybe they have a respiratory thing where they can't breathe with a face mask on, I don't know. But you do need to be aware of that, because if their doctor says they can't wear one, you might need to provide a accommodation for that, and the governor's order does make an exception for those instances.
Great, thanks. So this is back to FFCRA, I think. So as an example, if a grandparent typically provides childcare during the summer and they're not available for any reason, is the employee not required to seek out alternate care and show evidence that they have made an effort to find alternate care?
Well, Sarah, I don't know if you have any comments on that, but generally speaking, no. Um, you are not allowed to request evidence of their search for childcare. Like we said, they're really limited in what you can ask for. All you can ask for is proof that the child, or either a statement, and in the case of a school or a daycare center, a posting of some sort that shows that the place of business is closed or unavailable. I don't, the, there are really limited questions that you can ask of these employees, and none of those questions include how hard did you try to find someone. So you can't really push too hard on that if they're coming to you and making a statement that says, I am unable to work because I do not have my child care provider available. And if they say, I normally have my mother-in-law take care of my kids, or my father-in-law take care of my kids, and they're sick so they can't do it, or they can't leave the house because they're under an isolation order due to their healthcare provider, then at that point you kind of have to take their word for it. You can have a policy of your own for the business where you say, if employees fabricate or mislead or lie to the employer in order to receive leave, then that could be subject to discipline. But it's hard to really prove that, and you could get yourself into some murky waters if you start asking too many questions or trying to get too much information out of the employee about why they don't have childcare available.
Thanks. So back to lodging related question. Is any way to prevent sort of going to court to fight a lawsuit in terms of maybe having a guest sign something when they're checking into your lodging property, that kind of thing, or those types of things
Yeah,
advisable?
so I definitely think you could include a waiver for employees who are not employees, but for people who are checking into your lodging facility or, your rental. And that could potentially help you in defending a lawsuit. There really isn't any way to prevent people from actually bringing a lawsuit, unfortunately. That people bring frivolous and lawsuits that are just based on very little, and there's nothing that we can do aside from the mechanisms that are in place under the law to deal with those issues, like moving to dismiss a lawsuit. But those are all timely, costly, and I understand how frustrating that is. So I think your best bet is to attempt to get a waiver drafted for folks that will protect you in the instance a lawsuit is brought.
Yeah, and so like Sarah said before, a lot of this guidance and these laws are changing a lot too. So I think that your best bet is to document everything, whether you're concerned with your employees or with customers or renters, as it may be. Make sure that you are documenting your efforts to reduce the spread or to reduce potential exposure or infection. Make sure you're documenting what guidance you've given or not given. And that way, like Sarah said, when one of these suits comes up, as long as we can, well, not as long as, but most likely if we can show a defense that you were doing everything that you could do, then that's going to help protect you. We can't necessarily prevent lawsuits and Maine human rights complaints from happening. I was just talking to Sarah about this. Only 6% of the Maine human rights complaints in 2019 were actually found to have reasonable grounds for discrimination. So that shows you that there's a lot of dismissals and findings of no reasonable grounds for discrimination. So what that tells you is that people bring a lot of lawsuits when they don't actually have a reason to, or they don't actually have grounds to do that, which is a burden on employers, and we're sorry you have to deal with that. But what we want to do is make sure that we can defend our actions as employers and as business owners, and make sure that we can show why we did what we did and why we thought that was the right choice, and that we're not doing things to discriminate against anyone or negligently that could potentially cause someone harm. So I think that that's really what's important right now, is that you make sure that you are keeping records of what you're doing as a business and as an employer, to make sure that you have evidence of what decisions you were making if one of those frivolous lawsuits unfortunately comes your way.
Super. Thanks. So we're nearing the end of our time, and I have gone through the questions that have been presented so far. I do have another one I just want to kind of put a fine point on with you both, and then that maybe will allow anybody with a last minute question to chime in as well here before we wrap up. But Sarah, you kind of addressed this before, but I do get all the time employers saying, I have employees on unemployment, and with the federal $600 a week add-on, they're making more than I'm paying them, and they don't want to come back to work. And what do I do? So you touched on that a little earlier, but it comes up so often that I just want to kind of put a fine point on it and see if you have any other thoughts or guidance on that.
Yeah, I mean, so as I said, I think the first key is to be letting unemployment know that you've called that person back to work. And to let the person, when you make those callbacks, if you have somebody who's saying, I don't want to come back to work right now, that you explain to them, we're required to let unemployment know we've given you an offer of work. You may not be eligible for unemployment. And to go forward. The other thing is to really, I think, fully understand why that person, doesn't want to come back to work, and whether if it's related to a health condition or related to something like that. You may have some other requirements under the ADA for accommodations, or to provide some sort of aid to that employee. But generally what I'm seeing is folks who just don't want to come back because they are able to collect unemployment. And I think by letting them know, one, that you do have to alert unemployment that you've brought your employees back to work, and that two, we understand that this is a difficult situation. Explain to them what you're doing to make them safe. But if it's your decision that those folks have to come back to work, that you're not going to be able to guarantee the work for them in the future, and that that will be a circumstance where you may not have them. The problem is, a lot of employers, they don't want to push quite that hard, which I think is okay too, because a lot of employers are saying, I really need these people to come back to work. So some of them are making accommodations for people who either are nervous or afraid to come back to work, or who have issues at home that they have to kind of deal with. And I think that's fine to make those accommodations. You just want to make sure that you're doing it in a non-discriminatory way.
And I would also like to add in that, if it's purely an issue of they're making more money and that's their only concern, which, it might seem that way and might not actually be the case. Obviously, it's our inclination to believe, well, they're making so much money, why would they want to come back? Like Sarah said, you might want to find out if it's related more to safety concerns or related more to their own personal health, and what accommodations we might need to make regarding that. If it's really just about the money, there is a provision in the CARES Act which provides that extra $600 to employees or to individuals who are on unemployment, that creates an anti-fraud law. And what that says is that if individuals are either making false statements or failing to disclose a material fact, such as that they have work available to them, that can be considered fraud under the law, and it could result in either future denial of unemployment benefits or even possibly criminal prosecution. And again, we don't know how well this is going to be enforced, who's going to be enforcing it. But that's some teeth there that says, to employees, you can't just say, I don't want to come back to work and get this $600 extra a week, because if they're being offered work and you're telling them that they have work and you're telling unemployment, I offered this individual to come back to work and they're just refusing for no legitimate reason, then they potentially have some liability there themselves. How we address that with employees, how we make sure that employees know that, is another issue, because you've got to be a little gentle. You can't, seem to be threatening them, saying, I'm going to report you for fraud if you don't come back to work. We got to be a little careful with that. But there are some restrictions in terms of what employees are allowed to be doing. They're also limited in the number of weeks they can take unemployment for. So there's only so much unemployment out there for them. It is a substantial amount. I think it's about half the year. I think it's 26 weeks. But eventually that's going to run out, and presumably they're going to want their job back and not have to go find a new job. So, making sure that you're making clear that this is the return to work date. If you have a legitimate concern about returning to work, please communicate that to us. But otherwise, you are expected to return to work, and that we cannot guarantee your job will be held for you past a certain date. Those are all ways to make sure people know that, because they can't stay on unemployment forever. And they also could be subject to fraud if they're claiming to not have work available when they do. Also, I know that when an employee certifies that their unemployment weekly claim, they are asked, specifically related to COVID-19, if they have a return to work date. And if that date that they're giving doesn't match up with what you're telling unemployment, then unemployment may look into that as well. So if they're saying, if you tell unemployment their return to work date is May 20th, and they're saying my return to work date's not till July, I want unemployment through July, then that's not going to match up. And in theory, unemployment should be flagging that and saying this is, someone who is, not lining up with what their employer is telling us, and potentially is not eligible for unemployment anymore. And again, they're potentially risking their own problems with a fraud claim, because they are now, telling unemployment something that may be blatantly untrue. And so again, there's a lot of layers to this, and it's pretty complicated. I think it's important to really communicate with your employees. Be careful what you ask for, be careful what you say, but also, make sure that you are informing them, like Sarah said, of the precautions that you're taking, why you feel it's safe for them to come back, why you want them to come back, and what you're going to do to make sure that they are in a safe environment when they do come back to work.
Right.
I also note that one of the attendees here posted that there is a notice form that you can use, that the DOL uses, which is a notice of a return to work date, and that there's a fax number on the bottom of that form that you can fax it directly to the Department of Labor. I have had employers who are having trouble even by fax getting through to the Department of Labor, but that may be getting better at this point, is my guess.
Yeah, I haven't heard about their website crashing recently, so hopefully that means they're getting a handle on things.
Yeah, right. All right, well, we're pretty much at the end of our time. Any closing comments from either of you that you wanted to share? We're really grateful for you spending time with us today.
Well, I would just say, I always like doing these presentations with the chamber groups, because I feel like I do chamber presentations some, so I can almost picture some of you sitting right in front of me right now. And, when I'm doing one of these presentations, it feels like I'm kind of doing a hometown presentation, right? And I just want you to know, I do think about all of you a lot. I think about I know how hard this has been on some of your businesses. I know how difficult it is to navigate all of this stuff. And for those of you, I know that it's a stressful time, and I'm really proud of you. I'm proud of you for keeping your businesses going. I'm proud of you for, you know, being able to just dig in and come up with creative solutions and to try to keep these businesses. These are a labor of love for you all. You have put so much time and effort and capital and work into your businesses, and I know that you I know this is hard, but I think you're going to survive it, and you're going to come back and be able to thrive, and we're happy to be able to provide you information to help you do that.
Great.
I don't know don't know you all as well, but I can say that the folks I've worked with down Penn Bay area have all been some of the nicest, most hardworking people I've met. I was really excited to do this presentation because everyone that I've met down there has been so great. But I mirror Sarah's sentiments that, you know, like she said, this is a really difficult time, but it's really been impressive to see how employers are, you know, managing to pull through. It's been impressive to see how much employers genuinely really do care about their employees and want the best for them. And so, you know, we are so happy to be able to work with you to try and make sure your business is sustainable and to make sure that, you know, everybody survives this unprecedented situation as best we can. So we appreciate you letting us work with you and chat with you here today.
Super. Thank you both very much, and thanks to everybody who joined us today. And again, we have recorded this session and be making it available a little later on our YouTube channel for those that you might know who are not were not able to join us. And continue to keep in touch with us at the Chamber. We're here for you, and check out our website and Facebook page for upcoming events and information, and certainly shoot me an email at tom@camdenrockland.com if there's anything else we can do to be helpful. Thanks, everybody, and have a great day.
Thanks, Tom.
Thanks. Bye-bye.